Inspector Besigye, and Captain Dennis.
We wish to make an amendment in the charge sheet. And a copy of the amended charge sheet is Your Worship. Unless an objection, unless the defense has an objection, we should have it read to the accused persons.
I hope you are aware that I don't have personal.
You can't receive before I tell it,
I'm not in personal contact. So in other words, what I'm saying is I will not admit an amendment now because I don't have instructions to proceed in the matter. My instructions in this kind of like yes.
Most of them, but I ideally thought you wanted that you had the power since the matter is just coming up for mention and not for hearing. Unless my senior colleagues have a contrary view.
Definitely. Your Honor, an amendment is not just a routine thing. It changes the character of the case. We therefore want to be before the trial court and that the prosecution should give us advance information so that we can give an informed response. If we want to oppose, we cannot oppose something we have not seen. This is an ambush.
And for state, if you are not aware, the magistrates are so we don't have any of them. The chief magistrate. That's why I'm stepped in this case. And this guy is nothing much.
Yeah. So, Your Honor, before you, we request that the state now gives us a copy of the charge sheet so that at the time we need to respond, we are able to respond. We will appreciate that guidance from you.
Also, please, I think this, yes, we have already admitted it on record. It's not important now, because it's not part of it.
I'm trying to forestall an ambush so that we go with a draft copy of what the copy, because it's not a draft, it is fully. The state has a disclosure obligation. This honorable court is obligated to...
You return the charge sheet.
Seems the court doesn't want to look even at the charge sheet, but for us, we want to look at it.
The court even has discretion to reject it, isn't it?
Yes.
Now you want me to give you a copy of the document, which the other trial magistrate has yet to decide whether to accept it or not. As we speak now, there is no amendment.
Yeah.
That's just a draft paper in maybe chamber, the DPP's chamber. But you'll address that with the trial chief magistrate, who is not here. Counsel, do you have anything to say?
Your Worship, we appreciate that Your Worship do not have now powers to deal with the matters, that yours is just to adjourn. But there were some applications that were still pending, which actually were adjourned today. There was an application that was adjourned today where we made some prayers for observance and respect of the rights of the accused persons, and the state was due to respond today. That is a matter which we thought Your Worship would be disposed of, given the fact that it touches fundamental rights. Fortunately, again, the trial magistrate is not the trial magistrate. The magistrate who is in the conduct of the matter is not around. So Your Worship, that would guide this honorable court in deciding the earliest date we can get. The other issue, Your Worship, is the fact which we want to be on record that the accused persons have been on remand for over 6 months now. For the record, Your Worship, they were remanded on the 20th day of November 2024. And yesterday...
You were remanded on 20th?
20th. They were picked from Nairobi. To get the chronology of events properly, Your Worship, they were picked from Nairobi on 16th of November. That's when they were abducted and transferred back here to Kampala, and then formally charged before the General Court Martial on 20th November and remanded to Russia. 2024. So we intended to make some prayers before the trial magistrate today in regards to their continued detention or remand. But we appreciate we appreciate the circumstances, Your Worship. So since it's just a meeting they are having and it's a one-day meeting, Your Worship, we pray that we come back tomorrow for determination of those serious matters which touch fundamental rights. Because the continued detention or remand
So I don't know the practice that you've been in the trial one day, or I don't know. I know there are some adjournments that have been going on.
Yeah, I was bringing in these issues, Your Worship, of fundamental rights. There was an application for enforcement of rights, first of all.
True.
Yes, and also this.
Though I was given specific dates to adjourn. That's why I'm trying to reconcile with you and find out whether and what shorter adjournment.
It's the reason, Your Worship, we are seeking your indulgence now that you are in charge of the matter, to appreciate the gravity of the issues we are raising, because they touch fundamental rights. The first one about enforcement of their rights, their liberties, and also now the new one about the 6 months remand,
So,
which is a constitutional matter, Your Worship.
True.
Yes.
I've been given 5th of June and 2nd of June.
We request, Your Worship, if we could be accommodated this week.
So I don't know if I can give you any other date whether the trial magistrate will sit on that date. Because we have criminal days, we have civil days. That's the challenge we have. Some days are earmarked for civil, some days for criminal.
I request, Your Worship, you reconcile that with the constitutional command under Article 23. Yes, there is a matter of convenience for the trial magistrate, but also there is a constitutional command. I pray that you exercise your discretion to reconcile that, Your Worship, because 6 months remand is a matter we are challenging under.
So if the trial chief magistrate has given me 2 weeks, you want 1 day, maybe we draw the balance in between and adjourn it for 1 week. Because I would even be acting out of instructions of my supervisor. But since you're raising issues of constitutional rights, we just have to draw a balance. Because there are specific dates in these cases.
I would like, before we take any other decision, Your Worship, to have my colleague on record, our colleague.
Yes.
Frederick, Senior Counsel, I would like to have him on record.
Okay.
I'm very sorry I'm late. I got caught up by the prayers at the airstrip. When we adjourned last time, there were 2 requests. The first one was for the accused persons to be brought in a way which doesn't undermine their right to a fair hearing, or being brought and crowded upon as though they are very high-level criminals. The second one was a simple one, for the accused persons to be allowed to talk to their relatives, lawyers, and the people they lead after sessions in this court, as their right. We were quite surprised that the court required the state required the man to go and do research about the right of an accused person to meet his relatives. And the court required a month to retreat. Because in the earlier rulings, it's not a court of record, in this court, one application is made, and with your leave, Your Worship, in the Chief Magistrate's Court of Nakawa at Nakawa, in Nakawa criminal case number AA 27 of 2024, Uganda versus Makoka Samuel and others. I think they are the 36 accused. When a request was made that these people talk to their relatives after, rather than being hashed away to prison after trial, it was granted instantly, on among others grounds of common sense. So we are surprised that the state needs to go and consult that. The accused are saying, can I meet with the relatives after trial?
Your Worship, before you proceed, I want to remind a meeting.
No, I'm not writing anything.
So this is what I'm surprised for me. Because what council is talking about is what the Lord Mayor talked about. So I am wondering, I am in the puzzle.
So without
what very addition is bringing?
Senior Council,
Your Worship, if I...
without losing focus on so that probably you apply for mandatory bail.
Yes.
Now, I don't know if you've addressed yourself to the administrative circular issued by the PG. The one which bars magistrates' courts from issuing any kind of bail in capital offences. I don't know if you addressed your mind.
Yeah, we have superior authorities to challenge that. So it's the reason we said we are going to bring out all these arguments before the trial magistrate. All we are asking for is the earliest opportunity in light of the constitutional command, Your Worship, which is very clear.
And the earliest opportunity I'm giving you is going to be second.
That's why we are saying, Your Worship, in light of the command under Article 23, Your Worship, that would be too far.
And Your Worship, I hadn't finished my point before. Yes, and to the extent he's asking for an adjournment, his request a month to go and research and submit. So unless he's saying that he was aware the trial magistrate wouldn't be around before us, his duty today is to come, his submissions go on record, so that whenever the magistrate is available, they read, rather than adjourning, because assuming that it's not Your Worship who will hear the matter, court can record. It even records electronically, so that the magistrate, when they are available, reads the record and delivers a ruling. Unless he's saying that he must submit before that magistrate.
I think your absence has costed you.
The word is cost, not costed.
In your absence, prosecution was ready to proceed. And then the magistrate says, the trial magistrate is indisposable.
It's in a meeting.
Is in a meeting.
Yes. Not in his post.
I don't know whether this conversation is leading us.
So for me, I'm thinking...
Wait. I'd already informed you to proceed in this matter apart from adjournment. I made myself very clear on that.
I think
And I've been given dates. I have 5th of June and 2nd of June. And Council Lukwago, you are trying to negotiate on that date. And I said, if I'm not
reconciling that.
Reconciling.
Yes,
and
with the
I
command of the Constitution.
If I'm to go against the instruction of my supervisor, the direst move I can make is to give you next week on Wednesday. But beyond that, it's impossible. Because even what I'm doing now,
can we take a month?
Because I've been given these dates,
which is not available.
we
they are here, I have them.
we appreciate that you have a command. But also in the hierarchy of laws and administrative rules, the Constitution is higher than all of them. And whereas we understand you have no mandate to proceed, is it possible to give a date even tomorrow in view of the command of the Constitution? That's all that we are seeking, the earliest date possible.
Meet relatives after court trial. It wasn't the presiding magistrate, it was a standing magistrate. So, and the record is very clear. It was apparent that the simple request to see relatives was made by a standing magistrate. not the prisoner.
Last time when we were here, doctors, lawyers told me they wanted to meet him, and I remember I permitted it. We reconciled with the prison authorities, and they allowed the doctor to talk to his relatives.
No.
They didn't.
My lord, that is why we made
Doctor,
a
is
request.
that true?
That's why I made a request that they are allowed to see him after here. It is not a problem if court can secure that they talk to him, not an offense.
So where are the relatives?
And my lord, the
You see now the special
and my lord, it is here. It is here.
I will just limit the relatives. I'll allow them to speak to him, but I'll limit the relatives. We can't have the whole village coming.
Your worship, the request from that day.
So,
Your worship, that's for the record. The request from them second-rate citizens in any way. They are like you and me. Otherwise, when you say that they meet only certain people, then again, the assumption is that for the others, these people are a little bit guilty, or they are not innocent as others. They are like you and me, Your worship.
I'll only permit around 5 relatives to meet him in the presence of the lawyers. The rest of the community will move out of court. We shall have prison authorities securing the place, not necessarily inside, but around. So that's my decision. And it's not going to take long. You should have like, I don't know what you want to discuss about, but 15 to 20 minutes.
Your worship, that day
I'll come back on 29th of May.
Your
She's the one who gave us this date, and it was an adjournment in an open court. We are treated to a surprise today under very suspicious and mysterious circumstances. The magistrate was not around, the trial magistrate wasn't around. And the explanation was not satisfactory because she's not indisposed, she's not on any special duties anywhere. We are simply told that she had gone to attend a meeting with the registrar. You can imagine. You abandon a matter of this magnitude, a matter of great public interest, touching issues of national character, touching, the constitution of this country. Then you give priority to a meeting whose agenda is not even known to us. We feel this is very, very unfair, grossly unfair, because the trial magistrate, even if she had a meeting, ought to have attended to this matter first. That meeting could be held any time in the day or any other day. Was it an emergency meeting? Did any emergency happen at the High Court today that warranted the Chief Magistrate to abandon this matter and go for the meeting? It's really baffling to us. And of course, this speaks to the mischievous mission of this regime to keep Dr. Besigye on remand for forever, perpetually, because you are aware they have spent 6 months on remand since 20th of November last year. They were kidnapped from Nairobi on 16th November last year, arraigned before the General Court Martial on 20th, same month, and thereafter remanded to Luzira. So they have clocked 6 months on remand. That is yesterday, that's when they clocked 6 months. Now, the Constitution is very clear under Article 23. If you're facing capital offenses which are triable by High Court, and you have been on remand for 6 months without being committed to High Court for trial, you are entitled to a mandatory bail. The operative term or phrase in that article is that the accused person shall be released on bail on such conditions as court deems fit. But the command is that they will be released. Now you had the standing magistrate hinted on some guideline that was recently issued by the Chief Justice, a practice guideline. That guideline restricts the jurisdiction of magistrates in granting mandatory bail. We are contesting that. Because if you juxtapose a practice guideline with the constitutional command, which in one reigns supreme, it's obvious even to an average Ugandan who is not a lawyer that the Constitution takes precedence. So this is the whole point we are making, that the Constitution now, by construction and operation, the Constitution by construction has declared Dr. Besigye a free person as of yesterday 20th. So now the magistrate was just required under that particular provision today to confirm that and operationalize that. But the dictate of the Constitution is that Dr. Besigye should be free as of yesterday 20th of this month, because he has clocked 6 months on remand. So definitely the melodrama, the gymnastics played today were orchestrated purposely to frustrate this, to frustrate the release of Dr. Kizza Besigye. That explains the mysterious disappearance of the trial magistrate, with all due respect.
Talk about the amendments to the execution. What can you say?
We believe they are on a fishing expedition because they have failed to assemble evidence against Dr. Besigye. They tried to come up with some trumped up charges of treason and misprision of treason, which they could not substantiate. And all this time they have not conducted the investigations in this matter. You are aware they put in an application to open Dr. Besigye's phone and access his data, which up to now is pending hearing. So that charge sheet is an attempt at fixing something new. I mean, trying to plug up loopholes in their case, which we are sure is going to collapse on its own way, as a pack of cards. It's just going to collapse.
Talk about
For us, we are determined to put up a fight for the release of Dr. Kizza Besigye, because the Constitution commands in Article 23 he's entitled to mandatory bail together with Obed Lutale. So come rain, come sunshine, we are here, and we want to put the Chief Magistrate, Trial Magistrate on notice. It's not going to be business as usual on 29th. Our weapon is the Constitution. It's the Constitution which puts in place this particular court. And it's the same Constitution that has commanded this honorable court that please release Dr. Besigye after spending 6 months on remand. So no circumventing that particular provision. We shall not allow any gymnastics being played on that day. Zibu. Nti emyezi mukaaga nga giweddeko nga tewaliwo committee papers. Olina obuzibu tebanna committinga Dr. Besigye ne Lutale for trial. Ate nga ssemateeka mu article ya 23 gamba olina obbawa mandatory bail. So balina obuzibu bo bennyini ogenda mu maaso ne Mateyo. So tugenda kukomawo ku lwa 29 naye Lutalo okontinuinga otya with mention after 6 months ng'omuntu ali ku rimandi ng'ate ssemateeka gamba bw'amala emyezi mukaaga nga tumuleeseeko bujulizi mute. So tugenda kudda wano ku 29 lugenda kuba Lutalo, era twagala okuteeka mu magistrate ono ku notice nti tukomawo olutalo si lwa ngumi si lwaki naye lwa ssemateeka. Ffe ekyokulwanyisa kyaffe ssemateeka ennyingo eya 23 egamba nti Dr. Besigye alina okuteebwa. Tojja kuleeta ka practice guideline nti Chief Justice alina akateeka ke yafulumya akagamba nti tolina buyinza nga ssemateeka agambye oyo mutee ate olusayitinga otya akateeka akakoleddwa Chief Justice. Olutalo tukomawo wano ku lutalo, era twagala okumutegeeza Trial Magistrate tukomawo 29 ku lutalo kubanga ssemateeka amaze okutta Dr. Besigye kamaze emyezi mukaaga ku rimandi nga tebannamuleetako bujulizi. That is it.
The Constitution of Uganda, Article 23, Sub-Article 6, is very clear that if someone is charged with an offense and spends 180 days in custody before that offense or those charges have been committed to the High Court, which is the situation of our clients, they must be released on bail. Dr. Besigye, Obed Lutale have spent 6 months as of yesterday, not even today. Therefore, it is time for the High Court to grant them mandatory bail. So we were simply telling the court was saying that the magistrate only had instructions to adjourn to a specific date by his superior. Our argument is the Constitution of Uganda is superior to the command of a supervising magistrate. And because it is time to grant bail to Dr. Kizza Besigye and Obed Lutale, as per the Ugandan Constitution, we should get a date that is close enough so that we can address the issue of bail. We have been given the 29th. We would have wanted tomorrow, but there is the bail application pending before the High Court, and we are going to move there to see whether we can be given an urgent date. Because by law, Dr. Besigye and Colonel Lutale should be out on bail now.
You've talked about saying.
They are strong of spirit. Under detention, you can only be as well as you can be in those circumstances. But I want to tell the world they are strong of spirit and determined to fight these charges, which they believe, as we do, are totally unjustified, to the end. On my left is Monsieur Larifu Said, an advocate from Comoros, but practicing in France and other jurisdictions. He was the lawyer for Ousmane Sonko, who is now the Prime Minister of Senegal. Let him say a word or two. And he was in Tanzania. He is among the observers who managed to go in while we were deported.
Nga tebawebuleseko bujulizi bakola committee papers ezigenda mu High Court okuwulira omusango abantu omuntu oyo ajja kuteekwa gye bayita mandatory. Naye tumanyi bulungi nti waliwo practice guidelines Chief Justice yakumye ennaku ezo ng'aga nti ba magistrate tebawenga bail, eno mandatory bail yadde emyezi 6 giweddeko bw'obwo buyinza bwa High Court. Naye era mu High Court naye twateekayo bail application tennaba kufixingibwa. Neffe olwaleero tuzadde tuzze nga tumaliridde nga tulina ne authorities oba amateeka gonna ge tuzza okusaitinga agalaga nti kooti eno erina obuyinza obutta Dr. Besigye wamu n'Obed Lutale nga basinziira mu nnyingo ya 23 yadde waliwo akateeka Chief Justice ke yafulumya gye bayita practice guideline egezaako okubagaana okuwulira bail application eyo. Ekyennaku tutuuse wano nga magistrate taliiwo. Nene ensonga ze batuwadde nga tezimatiza nti ali mu meeting ne registrar ku High Court. Olunaku olukulu bwe ruti nga omusango gukomawo nga waliwo ensonga ez'omuzinzi ng'eyo ya mandatory bail nti ono bamaze emyezi 6 ku remand nga tebawuzesebwaga n'obujulizi tebufuluma, ate magistrate lwabuzeewo. Ekyo tukyewuunyizza nnyo era kitukubye enkyuko y'amaanyi. Era ono azze his worship Elias Kakooza mulabi agambye ekimu ye yazze na instructions mu Adijan bongereyo era nga anoonya bunoonya lunaku lulala yadde waliwo na application gye twali tutaddeyo enforcement of rights n'ebirala. So kitukoze bubi nnyo era kitulaze nti waliwo emizannyo egizannyibwa yadde ko tugiwe ekitiibwa naye waliwo emizannyo ezizannyibwa kubanga olwaleero ffe tuzze tumaliridde nga tubagamba ennaku emyezi 6 giweddeko yadde bali saitinzaako ka practice guideline naye tulina authorities eziraga nti balina obuyinza kubanga kiri mandatory. Katulinde naku z'omwezi 29 ze batuwadde, naye ate era tugenda ne mu High Court olunaku olwaleero naye okulaba nti ensonga ya bail application naye egobererwa ate nga ne wano kubanga ekikulu kya byonna bano kye baagala kye tumanyi Mwami Museveni kyayagala kwe kuza Dr. Kiza Besigye wamu n'Obedi Lutale mu General Court Martial nga bakoze ekiteeka kyabwe kye bakubiridde amangu ne bakomyawo bonna abantu abali mu General Court Martial kooti negala emisango bagize mu civilian courts bano baagala kubazzaayo. Mwami Muhoozi mutabani wa Museveni yagamba nti singa Byanyima Honorable Winnie Byanyima talekeraawo kusojja Muhoozi ku Luwonzi yali muzaayo ti yalizaayo Dr. Besigye mu General Court Martial kakati ng'omulaba nti ye eryanyi lirye lyakozesa era lyeryanyi lyagezaako kutulaga wano naye naffe tumaliridde olutalo olukyagenda mu maaso.